Nigel Abbott, SMEtv. Well, today I'm sitting in David Bates's shoes because he is actually our guest. He is the expert on HR. Thanks for joining us.
My pleasure.
Well, today's segment is all about the National Employment Standards. Now, I believe, Dave, there's 10 of them. So what are they and what are they all about?
Yeah, 10 of them, and I think that's more than enough because they're complex enough as it is. Yep. The idea of the National Employment Standards is that they're the minimum terms and conditions of employment that any employer covered by the Fair Work Act has to provide to their employees. So it covers things like annual leave, includes long service leave, sick days, compassionate leave, huge variety of things, including a maximum ordinary working week of 38 hours, which most employers aren't aware of either. So 10 minimum terms and conditions that employers must, as a matter of law, provide to their eligible employees. They are quite complex. Some of the NES have their own internal eligibility criteria. For example, flexible working requests, that's one of the NES entitlements, and that only applies to certain employees. So you have to work through them one by one to make sure that you're fully compliant with all 10.
And if I have, say, an employment contract with someone, am I able to amend them at all?
No, you can't amend the NES via a contract of employment. You could certainly provide terms that are more generous than the NES because remember, these are the minimum entitlements. So for example, a full-time employee under the NES is entitled to accrue 4 weeks of annual leave per year. So I could, if I employed you, Nigel, I could offer you a contract that says you'll accrue 6 weeks of annual leave. That's no problem. But I can't offer you a contract that says you'll only accrue 3 weeks of annual leave. And if I did, that term would effectively be void and I would still, by law, be required to give you 4 weeks of annual leave. Okay. So can't undercut the NES any way you try.
Yeah, that sort of sits above everything.
Yeah.
Absolutely. All right, so the other thing too, what if I'm non-complying with the NES? What happens then?
Just like if you're not compliant with one of the modern awards, it's going to end badly because there are significant penalties that can be imposed, up to $54,000 per breach of the NES. And given that most employers, if we were to walk down the street, call into 10 SMEs and say, tell us about the National Employment Standards, I would expect not many of them would be able to tell you because most people are just simply unaware of it. That's a real problem because they are legally responsible for making sure that they're providing those entitlements. One of the 10 National Employment Standards is an obligation to provide a simple A4 document to any new employee hired since the 1st of January 2010. And that document's called the Fair Work Information Statement. If you haven't given that out to your employees, you've breached the Fair Work Act. And one of the first things that a Fair Work inspector is going to do is ask you if you've done that. So you don't want it to end badly. Make sure you read through the 10 NES. And if you're not sure how they apply to your business, get some expert help.
And where would I find those out?
You can read the 10 National Employment Standards literally in 2015, Google National Employment Standards, you're going to find it. Expert services like Workforce Guardian, I'm the managing director of that business. We specialise in modern awards and National Employment Standard compliance. Speak to experts like us. We're there to support you and help your SME make sure that it's fully compliant.
So really at the end of the day, you know, when I'm looking at employment, I should be looking at the modern awards, NES, all combined and go and seek expert advice.
Absolutely. I mean, the biggest mistake SMEs make is they just ignore these laws. We call them the hope for the best employers. It's just all too hard and I'll leave it and worry about it another day. You can't do that. Just like you can't do it with your payroll tax, you can't do it with your super contributions, you can't do it either with these legal obligations that are imposed by the Fair Work Act. You have to get on top of it.
Yeah, terrific. Well, don't let that put you off having your own business or progressing your business or employing more people because there is expert advice out there that's very cost effective and make sure you go out and seek that to ensure that you're doing the right things. Anyway, Dave, great to sit in your shoes today. Thank you very much. Nigel Abbott, SMEtv. See you next time.